Hi, thanks for using My Court Coach. I'm Sarah and I'll be your instructor today as we discuss move-away cases. Move-away cases can often be one of the most challenging aspects of family law, and that's simply because of the emotions involved. No matter what, we are talking about a child being separated from a parent. There are a couple things to keep in mind with move-away cases. One is that these orders are subject to the discretion of the court, meaning that it is a judge-by-judge determination. And what may convince one judge may not convince another. So I'm going to go through the legal standards with you so that you can present your facts in the most clear, concise, and helpful way for your particular matter. The other thing that is important to understand is that the court cannot prevent a party from moving. The court can only decide which parent gets custody if one of the parents move. The court must assume that the party seeking to move will move whether or not the move away for the children is granted. So on to legal standards. What legal standard applies? If there has been no final judicial determination in place, in other words, there's no order that says this is a final custody determination, or there's no order that states specifically this is to be a Montenegro order, and we went over that in another video titled Legal Standards that the court must consider in making custody decisions. Or if the parties have had a final judicial determination in place, but they share joint legal custody, then the court has to use the best interest standards of the child. Again, that's in the video regarding legal standards that the court has to consider. Additionally, the court will need to consider factors that are set forth in remarriage of Lamouche as well, and those are as follows: the child's interest in stability, continuity in the custodial arrangements, the distance of the move, the age of the child's relationship with both parents, the relationship between the parents, but not limited to their ability to communicate and cooperate effectively, and their willingness to put their child's interests above their own, the wishes of the child if they are mature enough for such an inquiry to be appropriate, the reasons for the proposed move, and the extent to which the parents are currently sharing custody. If there has been a final judicial determination as to custody, then the primary physical custodian of the child has a presumptive right to move, and that's under the case of in remarriage of Burgess. However, the non-custodial parent then has the burden of proof shifted to them to show that the proposed move would cause potential harm. If the court finds that to be a convincing argument, then the court can stop the child from moving with the primary physical custodian. A couple other things to keep in mind: when a move away is granted, there is an automatic 30-day stay of the orders, which means that the move cannot happen for at least 30 days following the hearing. That gives the losing parent time to appeal the decision if they choose to do so. The other thing to keep in mind is that move-aways are often very costly and time-consuming, and that's because we are dealing with such a huge issue. Oftentimes, too, one of the parties may seek a custody evaluation where they meet with an expert who might do some psychological testing of the parties, some bond studying between the parties, observations, etc. And that's a process that can often take several months and cost up to tens of thousands of dollars. So move-aways are taken rather seriously, and there are significant rights extended to both parties in defending their positions in court, just to keep in mind. I hope you found this helpful. Good luck.